Real life.
Okay, we are live. This is Senate Finance. We are back. And we're going to
Yeah, go ahead.
continue
I'll
our,
just say hello to Andy, please. Hi,
I saw you, I didn't know. It's the Hackberry. So
he's undercover.
this is, all right, we are on to another completely different subject. This is the mergers and governance and communications union districts. And I think we wanted to tighten up language on the treasurer being able to just pass off his or her responsibilities to, the way it's written, it sounds like anyone. I can give it to my cousin while I go to Florida for a month, and we wanted to tighten that up.
Okay, so Maria Royal with Legislative Council, and I'll try to pull it up in just a minute, but I think the language, so the sentence now, this is under, as the chair just mentioned, the treasurer's responsibilities and duties. So the treasurer of the district, CUD, is appointed by the board, serves at the board's pleasure, and is not a member of the governing board. And then it goes on to describe the duties of the treasurer, and then the new language specifies that the treasurer may delegate any or all of the responsibilities described in this section, provided such delegation is approved by the board or authorized in the district's bylaws. And I did listen to your discussion. I think it was the word responsibilities that maybe seemed too broad, maybe tasks or duties or
Duties,
or even
if you
more
want,
specifically identifying things or.
I mean, I think duties work because they're talking about maybe having the treasurer be more like a CEO and managing and being able, I first read that, I thought, well, you gotta give it to a bookkeeper to keep the books or an accounting firm to keep the books. But you still have the responsibility of making sure they're performing.
I think you summarized it well in the comments that were made the last one. There's the other one that I did offer, and I'm curious if you have a reaction to this. It's the language seems so broad to me but if you can tell me this is boilerplate language that we have in other examples of state statute where we allow for treasurers to have all responsibilities segmented off, that would normalize this to me. Otherwise, just that word responsibility, you lose some accountability, and I think the importance of a treasurer, that is somebody that you hold them accountable. They can have other tasks. They need to invest it in the accuracy of the contents and actions that are being taken.
So I didn't find other examples that you could look at. I asked Tucker and haven't heard back yet in case there was something else to consider. Yes, you could definitely narrow it a little bit and maybe using the word like duties described in this section, but also maybe just specifying that the treasurer is accountable for ensuring that that somehow the accountability is not, I think that's what
The
you were
accountability
mostly.
stays with the treasurer, they can delegate the duties,
Yeah,
but the responsibility.
maybe being a
stays.
little bit clearer about that so that,
Okay.
and I can work on some language, get that.
Yeah, I know they would like us to get it going because
Sure.
I have a feeling they have some things they'd like to do. I don't think we're going to have anything else today. Okay.
I can have that tomorrow if you wanna.
We are
Tonight? What are you
hoping that
thinking
the
tonight?
House
Oh.
fulfills its promise or its hope that it will get the property tax or the 127 adjustment through all stages of passage today, and we're kind of holding tomorrow to go over that.
Sure.
But if you have it ready, I doubt that it's gonna take us all afternoon to go through it. So
Julian Kirby can only come in at 2:30, and there's time before that that's empty.
you have it done by then, we'll have you in tomorrow.
Okay.
Okay, good. Maybe we will put that one on for a possible vote on Friday. keep being reminded, we only have so many days left.
19 today.
No, 17. Today, 18th day, and 17 today.
I think Senator Ruth said yesterday that it was 19, the day after he made the event. Like that was the 20th day. I know that it's just.
This is the 18th.
It's not rocket science.
It's not
It
a
is.
lot
These
of
things only
time.
count.
Right.
It's how many days till last Friday?
We,
Saturday, Sundays and Mondays.
yeah. Okay, so, well, I'd like to try and get some of these out, because I think once 127 goes, we're gonna need to do some pretty heavy looking at the impact of the property. Property taxes going up, a possible 20%, so trying to clear that. If Maria, but Ben Marks is here. So. There he is. Okay, Mr. Marks, we're running ahead, so you won't have to wait so long. Welcome to Senate Finance. We just asked that you introduce yourself and who you represent.
Sure. My name is Benjamin Marks. I'm a resident of Cornwall, and I'm currently the president of the Acorn Renewable Energy Co-op. The presidency and the board are all volunteers who work to keep Vermont energy dollars local. So we were an early proponent of locally sourced wood pellets, and we've recently been doing community solar projects using Vermont's small business offering exemption to do public offerings of shares in solar projects to people who, for whatever reason, can't put solar on their own roofs or in their own backyards. And I'm here today to talk about Senate Bill 236 and about the proposed changes to 30 Vermont statutes, Section 248, which is the main section that governs creation of utility infrastructure in Vermont. I'd like to tell you all a little bit about an experience that we had with one of our community solar projects as it relates to the rights of interveners and neighbors. But that's who I am and why I'm here.
Okay. So the floor is yours.
All right. Well, first of all, thank you for having me here. I realize that Senate Finance is a bit of a stretch maybe to these kinds of renewable energy issues. But there is a section of Senate 236, which talks about the standards for intervention of neighboring landowners and others in a 248 proceeding before the Public Utility Commission. What this language does is essentially revert the standard for intervention to what it was before the current set of rules. And I'll give you a little bit of history on this. In the first part of this century, GMP permitted and built the Kingdom Community Wind Project in the Northeast Kingdom. And it was very successful from a regulatory point of view and from GMP's point of view. But I think that many of the project opponents to that were upset with the speed of that process. And in response to the success that GMP had there, decided to push and make the rules for participation in a Section 248 proceeding a little bit more like Act 250, which really governs real estate development. And I realize this is getting a little bit down in the weeds. I promise to spend no more than 60 seconds on it. But in general terms, Act 250 is an anti-sprawl development control piece of legislation. It's designed to protect the environment, sure, but its main impetus was to keep Vermont from turning into a series of strip malls with rampant development that had no controls on it. Section 248 of Title 30, in contrast, uses a lot of the same concepts as Act 250 in terms of ensuring that there's no harm to the environment and to aesthetics and so on. But it puts it in the context of a Public Utility Commission proceeding. And if I just make a simple analogy, I would say that Act 250 is a series of speed bumps or roadblocks that slow down development. And Section 248 of Title 30 is really a path to yes. It's more of an on-ramp so that utilities and other developers can get infrastructure built. And when you think about the policies behind that, it's easy to understand why. If you have a transmission line that needs to be built, you don't want to have a multi-layered approval process with many bites at the apple that slows it down. You want to get the infrastructure that you need constructed so that the lights can stay on. And that's an oversimplification, but pretty much a high-level explanation of why those two laws function the way they do. Well, after the Kingdom Wind project was installed, the rules in front of the PUC under the current governor, who was hostile to wind, changed, and they lowered the standards for intervention for anybody into one of these proceedings. Before, you had to show a particularized interest, which is a legal term of art, meaning that your interests are different than those represented by, say, the public advocates. So there is a public advocate, the Department of Public Service, and it traditionally has been the, maybe not the last word, but the most important word on issues like aesthetics. And the idea was that if a piece of utility infrastructure was going in, it was really affecting everybody, and that the public advocate should have the main role of protecting that interest. And so they would hire experts, build back to the utilities, submit their testimony and their views to the PUC, and be part of the mix, an important part of the mix, when the PUC was deciding on whether a piece of infrastructure should be built. Well, under the new rules, we had a community solar project in Shoreham, which was a small project, 1 acre, 150 kilowatts, serving about 40 households, all of which were Addison County residents who wanted to have the benefits of solar energy. We went to the town and we talked to them before we submitted our petition, and the town was wholly supportive. We had letters of support from the town. We talked to the landowners who had houses nearby, and we made sure that none of them had any objections to this being put in. And we did that because as a co-op and as a series of volunteers, we really didn't have a budget for a big legal fight on something like this. We wanted to make sure we'd solved all the problems ahead of time. So we submitted our petition and discovered to our dismay that we'd miscalculated in an important way, which was that there was a set of out-of-state landowners who lived down in one of the Carolinas who thought that having a 1 acre solar project next to their acres of land was going to ruin its development potential. And this is speculation on my part because they never actually said what their motives were, but they basically came in with a kitchen sink sort of response to our filing. And by that, I mean they raised every possible objection on every possible subject matter with a very aggressive attorney who did a great job of muddying the waters. The issue for us was not just one of expense, which we worked out by getting free representation from a volunteer lawyer, mainly yours truly, but really the timing of this. We had submitted our petition to get this project built in August of 2017. With all of the evidentiary issues that the out-of-state landowners raised, we didn't wind up getting a decision until April, May, June, July of 2019. July 26th was our CPG order date. The out-of-state landowners then appealed to the Supreme Court, and we couldn't start construction until those appeals were resolved. We finally got a favorable Supreme Court decision in January of 2021. And I believe I forwarded those documents to you, which if any of you are having trouble sleeping tonight, I would recommend them as reading. They go way down into the weeds and they'll put you to sleep guaranteed. But from a procedural perspective, and really from a high level perspective that I wanted to talk to you all today, the fact of these out-of-state landowners basically turned what should have been a 4 or 6 month proceeding into 2.5 years. In the end, I have to say, I mean, we had the burden of proof and persuasion on all factual points. We won on every single one in the sense that the issues that the opponents raised really turned out to have no merit technically, or when we got to the Supreme Court legally from an argument perspective, but they were able to fund an opposition to this project that put us years and years behind schedule. And as you can imagine, if you go to the public and raise money to purchase panels and purchase inverters and make all these expenses, if you raise your money in year one, but then don't spend it until year 3.5 when your permits have been cleared, you're really looking at a very different financial landscape. Anyway, the provisions of Senate 236 would tighten up these standards for intervention and really bring us back to the prior understanding that we had for years and years and years, which is that if you want to be granted intervention as a member of the public, you have to show a particularized interest on a specific set of facts instead of coming in alleging that there's an aesthetic effect on your neighboring land, which I think we can all be sympathetic to, but then manufacturing issues related to underground water sources that were really counterfactual. I mean, I don't want to allege bad faith. I think it was aggressive lawyering, but it really, the factual arguments that they raised had in fact no basis in reality. And with that pitch for support of this legislation, I'll stop monologuing and be happy to answer any questions you all might have.
I think that what the committee is struggling with is trying to find a way to help solar energy companies get to market, get to construction as quickly as possible. But we've been told if we take off the aesthetic criteria, then it won't be considered anywhere. And we're also concerned about protecting Vermont's landscape character, that there are places that are appropriate for solar power, there are places that aren't. And we're trying to figure out how we keep that balance. Lead 7's been brought up, there's places there because three-phase power is there. And
Right.
Three-phase power is an expense. So we're trying to find that balance.
Well, I guess what I would say is that the way I read Senate 236, it's not removing aesthetics from consideration entirely. It's really narrowing the field about who can argue about aesthetics, right? So I think you do want to have a public advocate in there, like the Department of Public Service, who's historically. I'm sorry?
So we will have the Department of Public
Service in there, yes, and you know, I should say that they in my particular case, the Department of Public Service had no problem with the siting of the project, which was well back from public roads and hidden behind some barns and so on. So the public advocate was absolutely fine with our project from a public effect on the public perspective. The town, from its own point of view, thought that the project was excellently sited, but the neighboring landowners felt that they didn't want their undeveloped parcel to be next to this array because of some potential future use for it. So I would say that Senate 236 addresses this by trying to narrow the field over who's in this argument. Is it you know, everybody, landowners who live 2 miles away and can see this as 5% or 1% of their field of view, or is it the Department of Public Service, who traditionally has been the public's advocate in terms of how this issue works? So I don't think passing this bill would remove aesthetics from the consideration of the PUC. I think it would narrow who had the right to argue about it in front of the PUC and in front of the Supreme Court.
Senator Gray.
Hi, Mr. Marks. Good to see you. Since you've recently dug so deeply into the record, thank you for that. Can you remind me of what the requirements are around filing in terms of, do you have to demonstrate a particularized interest? Do you have to be in a butter? Do you have to, you were saying someone 2 miles away, like what are the criteria for being allowed to intervene?
For that, I think you'd have to go to the Public Utility Commission's current set of rules in 5.100. And I can't recite them off the top of my head, but I could look them up for you and read them into the record if that would be helpful.
Well, I can chase that down. I was just trying to remember where to look. Because, when you say, well, someone 2 miles away could, intervene and complain on a criteria, then I thought it was a more controlled situation than that.
Well, I
It-
think ideally it should be. And I just on the record, I don't really have a problem with a next door neighbor, who's really, I could imagine a different set of facts than our circumstances, where a next door neighbor would say, I'm a retired school teacher. My home is my only asset. And if you build a substation on, next to my dooryard, it's going to have an effect on me. Couldn't you put it someplace else? In this case, we had interveners from about 1,500 yards and 2 miles away also come into the case and join with the neighbors under the current standards. And if you're looking for those intervention standards as they are currently, I'd look at PUC Rule 5.100, which governs net metering applications.
Okay, Sam,
Yeah. I'm Dick McCormick, serve on natural resources as well as this committee. It sounds to me like you pretty much described a slap suit. That you were just punished by an aggressive attorney.
Well, I think that's a fair way to describe how our litigation played out. But to be fair, the PUC, when they get these intervention requests, they haven't developed a factual record yet. That all takes place before the technical hearing, which tends to be towards the end of the regulatory process, if there is an issue to be adjudicated. In our case, I think we made a pretty good showing, and I think the PUC agreed that the interveners' witnesses really didn't have a leg to stand on factually. Whether that qualifies as a slap suit, or simply an aggressive attorney making a best effort, I couldn't say.
Well, you graciously made clear that you were not accusing the other attorney in this case of ill will. But I think there probably are instances where there is ill will, and we want to protect people from that. Certainly people doing good things like putting up solar collectors. But how do we do that without also making it more difficult for legitimate citizens with legitimate concerns to have their concerns considered?
Well, I mean, this is going to sound like I'm simply arguing for a golden age, but before the rule change that gave us our current intervention standards, there were avenues for people with concerns to bring them in front of the PUC. In fact, every project like this is required to have a public meeting at which members of the town or citizens or anybody with an interest can speak. The record of that public hearing is not evidence in the proceeding, but it does often suggest lines of inquiry that the PUC or staff can follow up on. So if there is a popular feeling against a project, for instance, in a particular town, the PUC and their staff attorneys can get an earful about that feeling at the public meeting that's already in the rules. What we're really talking about is who has a right to be in the hearing room and driving the scope of the proceeding. And I think in our case, a tighter intervention standard would have streamlined our 3-year process somewhat. Now, I mean, can you make everybody happy? I'm not sure that you can, but I would argue that the current rules have tilted the playing field too far in the Act 250 direction and have opened the door to delay of renewable energy projects, which, as you say, I agree, we sorely need.
Thank you.
Senator McDonald.
How closely or how far apart was the proposal from the town plan?
The proposal was consistent, I guess I would say, with the town plan, and the planning commissioner, the head of the planning commission, actually intervened in the case in support of the project. So I guess you would say in our case, there was pretty good alignment between how we cited the project and the kinds of things that the town plan said we had to consider.
So was it a part of the town that was designated appropriate for solar?
I see what you're saying. This particular town did not at the time have what we're now calling an enhanced town plan, or one that's been vetted by the Department of Public Service, where the town has actually set aside or indicated preferred areas for solar. We went the other route for getting a preferred site designation, which was to go with our plans to the select board and to the planning commission and explain what we wanted to do, and got letters of support from them based on the schematics that we provided. So that's how they made their judgment about consistency with the town plan. But they had not, as at that time, and I don't know whether they have since, they had not set aside land for solar or designated preferred zones the way towns who have more recent town plans may have done.
Thank you.
I bet you wish they had.
Well, I wish they had. I mean, we probably don't want to go down that rabbit hole, but I sit on Cornwall Select Board, and I know how difficult it is to address these issues. You might think it was an easy thing to indicate where solar is best, but a select board winds up picking economic winners and losers when they do that, which does tend to stir a lot of passions. So I know Cornwall hasn't done that either. I just to say, I'm not talking out of one side of my mouth as an attorney and another side as an elected official.
Yeah, there's a senator, right, one senator.
Thanks for the site to 5.100. And I'm looking at rule 5.117 in terms of party status. So F is names adjoining landowners. And so although I can imagine it might be galling that the people aren't residents, but they are living someplace else, but they are landowners, right? And they're adjoiners. So wasn't that the basis for their being given party status?
It was in the past, the way that it worked was that an adjoining landowner had to articulate a particularized interest, and then they would be admitted on that narrow interest, right? So if aesthetics was your thing, that was the basis on which you were allowed in the case. The way that the rules currently work, once you're in the case, you can present evidence on any of the criteria. So for instance, the landowners in our case alleged that they had an interest in aesthetics. In fact, these days, you don't have to make any allegation. You simply have to sign a piece of paper saying I'm an abutter, and you're granted party status automatically. Once they were in, they said, well, let's talk about groundwater. They had no expertise, and their expert was not a groundwater expert.
So I may, Madam Chair.
Yes.
So I'll just, do some more research because I don't remember the details well enough. But at the legislative administrative rules, which was recently looking at rules around party status, the PUC was talking about having yes, someone could intervene, but they played a sort of a gateway role. They were controlling what criteria that you could use in order to intervene. Like it sounded as though basically they qualified people so that you couldn't come in the door. And then as you are describing, then start asking about, I came in to ask you about the color of the wall, but now I want to talk to you about the lights and the parking lot and the drain. And so I have to find out some more, because there was, my understanding from that hearing was that they were discriminating once someone was in the case. It wasn't anything goes. Maybe it's a rule change that is more protective now compared to when your case came through. I don't know.
I think it's a question of how the rules are being interpreted. My sense was that Tony Roisman, who was the PUC chair when we were arguing this case, had been appointed by Governor Scott specifically because he was very friendly to landowner rights issues, and that the feeling, and this is a political judgment, I guess, was that landowners' rights had really been trampled on in the 248 proceeding, and my understanding was that, or at least my conclusion on reading the way the rules were revised, was that the decision at the PUC level was to expand those rights. So I guess what I would say is that in prior cases, under different chairs, under different board rules, you were allowed, particularly in a complex case, intervention on a single criterion, and that's really where you that was the lane you had to stay in. And if you think about, I mean, let's take it out of the context of my particular case. If you think about a case like the Northwest Reliability Project, which was a long transmission line, running up the center of the state, there were literally thousands and thousands of abutting landowners, and the idea of granting each of them, party status with independent abilities to investigate anything about the line really would have made for an unruly proceeding, just because there were so many of them. It would have looked more like a class action lawsuit. So the PUC does have the ability to tailor the intervention of its participants, but the bias has been over the last 10 years or so towards the protection of landowner rights and away from, I think, the efficiency of approving renewable energy projects. So that's my main concern, is not the landowners' specific interests in this, but the pace at which these cases go through. I think our case had the dubious distinction of being the longest case before the PUC from application to construction at that time. It may have been surpassed by some other case since then, but it was not a distinction I enjoyed having.
Okay.
Quick follow-up.
Yeah, and I've got some.
Just a quick follow-up, so I bring more of the story together. How was it that non-adjoining individuals who live a couple miles away were allowed in under the, kind of like you're saying that the adjoiner having party status then was allowed to have other people on their kitchen or whatever you would call it?
Oh, I mean, I think that there were a group of people in town who didn't agree with the conclusion that the town had come to. The most vocal ones were abutters to the project, but there were others who were further away who said, well, I use these roads and I'm going to have to drive by this, and it's going to affect my aesthetic experience of living in this neighborhood. Therefore, I should have the right to participate in this. To be fair, I think the PUC often takes in a lot more information than it cites in its order, and their job, in a sense, is to parse what information is significant and what isn't in terms of the evaluation of the statutory criteria with which they're charged. From our perspective, it made for a larger case, and once the we'll call them the further away landowners were granted status, an applicant has to make a decision about whether they're going to appeal that ruling in an interlocutory way to the Supreme Court or simply proceed with the case. And my sense is that developers uniformly decide to simply move on. That's okay. We've got a larger docket. That's just the hand we've been dealt. We've got to play those cards. But I think under an older standard, landowners who were 2 miles away really would not have been allowed in the case as not really having an interest that was any different from the general public. And that was not the case in our proceeding.
So they became a formal part of the, I don't know what you call the complaint or something against the challenge to the CPG.
Yeah, they became an adverse party. And to be fair, if you read the intervention order, and I won't send it to you because that'll, just put you further to sleep. The PUC does require parties who have similar interests like this to aggregate their efforts and to ask discovery questions together and so on. So they do make some efforts to make things more efficient. I think my question is more of a 10,000-foot one of, should these folks be in the case at all? And under the older version of this rule, they routinely were not. Now they routinely are.
We need to find out what the
Yeah.
rules were.
Well, we heard, for instance, that there will be public comment at which the PC said, well, we take public comment, we're not responsive to it, but we're listening, and what the public can do is raise, concerns that then the board will tune into in case they miss something, but that the criteria they apply to every case is already legally specified, so they might hear about things that aren't legal criteria for review, so, but it wasn't, it sounded less intrusive and more of a, the public might help the board see things they could have overlooked.
I think that's the attitude that the PUC takes. So they're very courteous and curious when they have these public hearings. And my sense is that they really do welcome all comers. If you all lived in Vermont public life long enough, you know that it's actually rare that the public takes an interest in specific questions of policy. But my sense is that under both the old rules and the current rules, those public hearings are required to take place. I mean, I think actually the public hearing requirement's in statute. It's not in a rule. And the board does listen.
Okay,
Thank you.
Senator McDonald, there's a question.
So I asked earlier about the town plan. And you described that this is a contest that has winners and losers. Under what if you have a town plan, the battle over who the winners and the losers are will take place as the town plan is being discussed and put in place. And if you're trying to develop solar and you don't have a town plan to use when you're trying to locate it, then the battle between winners and losers is going to take place later. So
Well,
the default is not, you meant, I wrote down what you said, that the decision the town had come to that it was okay to build it, it was a proper and appropriate to build these panels. When did the discussion about the decision begin? After the application?
no, before the application. So if the town had opposed this plan or this proposal, we never would have submitted an application. Like I say, we're a series of volunteers and we're raising money from people who are their money's literally being turned around and used to buy the panels and the racking and so on. So there was no really legal budget for a fight. And our entire process is really based on working with towns to find acceptable sites. We have our more recent project is on the Bristol landfill, which had no abutters with views because nobody builds a house with a view of a landfill. But it was closed, and the entire process from application to CPG was probably 4 months. A real contrast. So I don't want to get hung up on the procedural question of the quality of each town plan. Some town plans, newer town plans, often have designated areas for solar. Older town plans, like the one that we were dealing with, had what I'll call standards rather than rules, right? So it didn't say thou shalt build here and not there. It said here are the qualities that an acceptable solar array will have, and it listed them. And we went with them before we made our petition to the PUC, to the Planning Commission and to the Select Board to make the case that we met those criteria and wanted them as partners in the case. In fact, the town wound up being an investor in the project because they wanted solar for to offset their municipal bills and saw this as a good way to achieve those ends. So that the town was a participant and ultimately wound up being an investor in the project.
And they're the ones that were making the decision that this was a good idea?
Yeah.
Well, how can they be in judgment whether or not it's a good idea if they're the investors?
Well, I mean, first of all, those decisions were not contiguous. But the second of all, towns make those kinds of decisions all the time. You know, I mean, we decided to put a solar array on the town hall in Cornwall because we had a sense that we needed to walk the walk as well as talk the talk. And instead of paying somebody else or being a part of something, we made the investment ourselves and are getting the economic benefits ourselves. But in the town of Shoreham's case, they looked at the cost and the land purchase options or lease options for building their own solar, and looked at our system and decided it was the lower cost way to go. But it wasn't in that sense a sweetheart deal. They paid the same price as any other investor.
Madam Chair, the fight's gonna take place. And it should be based on a decision and criteria that are established, not what happens to be convenient at the time. Or you're gonna have problems.
Can I make one further comment? Towns that have an approved energy plan and which have their town plans modified to designate where solar should go, that is not a guarantee that a project will be built in that location. You still have to meet all of the statutory criteria of Section 248 and prove that you're not going to harm the environment or harm other local investments, or, you know, the particularities of that still get judged by the PUC. What crucially changes is the standard that the PUC devotes to the town's position on that matter. So it goes from a due consideration to substantial deference standard when the PUC is considering the position of the town. So in our case, the town didn't have an enhanced plan and their views were given due consideration, which means the PUC weighs it along with all the other factors. If they're for it, it's a scruple on the scale for the project. If they're against it, it would be a small vote in the other direction. Once a town has an enhanced energy plan, the PUC gives due deference to their position, which I mean, my lawyerly read of that is we'll do it if we can, right? So not if the project violates one of the other 248 criteria, it's not going to happen. But unless we have a really good reason to rule against a town, we're going to listen to what the town wants. So it's not a lock. It's just another factor in the decision-making process.
I'm gonna have to wrap this up because we've got, I hope he's waiting in the hall, our next witness, and then the witness after him, I see is already signed in online. So this is not the end of this conversation. I've got a list of a bunch of people I need to hear from. But I'm gonna move us on, and Peter, if you open the door, I hope that Will Baker is out there.
I just want to thank the committee for taking the time to have this conversation, and I hope it's been helpful to you in your deliberations. Good luck, and thanks for all you do.
Okay, thank you.
Thank you.
Okay, Will, you might as well take the hot seat. It has been brought up to us that solar arrays don't pay what some people might consider their fair share on their property taxes. That I remember passing that the land underneath the solar array was appraised as open land. But can you bring us up to date on how that whole system works?
Sure. Yeah, for the record, Will Baker, legal director at the tax department. And earlier today, I sent into the committee a fact sheet on solar power taxation that you can refer back to later if you'd like to. But you are correct. When listers and assessors are looking at property, if they're looking at perhaps your house or my house, they look at fair market value, and there's a whole, academic world of how you do that. But if it's a solar generation facility, the law says stop. Don't do what you do with these other properties, do something different. And so let's start with the land under the solar facilities. Now, these are solar facilities of 50 kilowatt or greater, and I'm not an expert on you know, what that.
Yeah,
What it means
how
is,
many of the panels, that's what
Yeah.
I'm gonna,
what it means is bigger than your typical like residential
okay,
rooftop or pole system.
okay.
You know, the solar generation facilities. If you've got one of those, we'll start with the land first. And you're correct, Madam Chair, that the land is under law, the land is to be assessed pretending that the solar facility is not there. And the town is to use their land schedules to determine the value of that land with no adjustment.
So it would go up over time as the value of open land goes up,
That's right. Even if there's a lucrative solar lease,
right?
the use of the land, if there's a solar lease on there. In a different situation, a assessor might consider that, you know, maybe they can come approach but the law says, no, forget about this, anything being built. Being on that land, you're looking at the land and the land schedules only. And that's for municipal and education tax. So that's the land.
Yeah.
Then you got the facilities on top. If it's a generation facility of 50 kilowatt or more, then there's a capacity tax at the state level, which is a tax on $4 per kilowatt of capacity, nameplate capacity. So it's not how much it generates, it's what it's rated to generate. $4 per kilowatt for this uniform capacity tax. And that's paid to the tax department. And it's last year it was a little under $1 million to the ed fund, 200 filers for that tax type. So it's
So if you go to the ed fund,
it does go to the ed fund, that's right.
good,
And if you pay that uniform capacity tax, there's no education tax on those facilities.
okay, so you pay uniform facilities,
Now, on the municipal side, they do tax the improvements on the land. And on the municipal side, the law tells the town to appraise those improvements using a discounted cash flow analysis, which is a method of appraisal where you look at the expected future profits in an investment and you discount it to present value. And there's a complicated formula that the property valuation and review division at the tax department does. And it's a sort of a web-based system. You go in, you put the inputs in and it produces the values for the town officials. And so you enter the inputs into that analysis and that gives you the present value with it. And the law says to do an expected 25-year lifespan for that facility. That's by law. And so that is calculated and the law says to take 70% of that value. So you discount that value by 30%, you take 70% of that value and you put that in the grand list for each and every year for 25 years or for the life of the actual life of the facility there. That's the municipal tax.
I'm having trouble visualizing that, yes.
When its useful life has ended.
Then if it's finished and removed, then you would stop doing that. And you would, if there's no facility there, then it would revert back to fair market value of the property at that April 1 of the following year.
I believe I heard you say that if you pay the UCT, the $4 per kilowatt hours, you don't pay the education tax on the land, regardless of how much land we're talking about. So if you have a 200-acre parcel and you've got maybe an acre worth of through 200 panels hitting this threshold, you're paying the $4 per the kilowatt. Does that mean the whole 200 acres don't pay any education taxes?
No, the uniform capacity tax is for the improvements. So the land is taxed, both education tax and municipal. And it is for all the land. And you look at it with regard for what's built on it. And they just use the land schedules And then the UCT is for the improvements on the, yeah, and I'm not a expert at solar, fair market value of solar facilities, but my understanding from the reason why this was enacted and my understanding from the property valuation folks at the tax department since then is that this is a reduction compared to fair market values for the solar facilities. So I think you're right when you hear from the public that they're paying less comparatively. I think that was the intention of the law. It went in 2013. And I think that is what the intention was. It was a reduced and predictable way to assess those.
It was meant to help what was then just an emerging industry, not be hit with property. I mean, how do you, the fair market value of the solar field. So I guess we decided, and I wasn't here. You
used the word earlier that you pretended that the structure was not there. And that pretense continues, as you said, until it's ended its useful life and it's removed. And when the decision was made, the concern was that if you didn't have that provision, that suddenly, when it's removed, you have this section of industrial or commercial property that is now subject to further development because it's already been found to be commercial property and the pretending has expired. And Senator Starr was given the mechanism that we're now operating under. And for the weekend to come back and listen, he was to come back, he wanted to use that land that farmers owned or people had forestry to earn them some money. And when this provision was made, he came in on Monday, and if I can quote him, he said he thought about it all weekend and he couldn't find anything wrong with it. Which is, which for that gentleman, this is about the highest enforcement you can get. But it was designed the way it is, not by accident. But if you were going to use prime ag land for this or forest freeze down, you didn't have a benefit after the useful life to then turn around and claim it to be commercial and industrial property and go ahead and say it's already been used and we can do whatever we want with it. So it wasn't an accident or a quirk of fate, it was planned that way.
Okay. Any further questions for Mr. Baker? Right, thank you. I think that just gives us a good factual basis to the rest of it.
You're welcome. And there's a link in my document testimony to our fact sheet, which has for listers about details about how we go about doing that. If you have further questions or you're happy to come back and discuss it more.
Okay, thank you.
Thank you.
Okay, we have one more witness today. And my computer is not loading again. It says Safari isn't working. I've been told that there are issues at this end of the hall with computers. I've never had this problem before. But I've sent it down to Shotty and this is it. So our next witness is Dr. Marvin Malik, and Dr. Malik, I believe you are here to talk on S-230, which is care and advantage plans.
That's correct. Can you hear me?
Yes.
Thank you very much. Should I briefly introduce myself?
Yes, just introduce yourself for the record, and if you represent anybody, tell us who.
Okay. So my name is Marvin Malik. I'm a medical doctor I trained in internal medicine, spent most of the first half of my professional life in community medicine and primary care, and most of the second half, including currently as in-hospitalist medicine, inpatient care. I'm an active member of the Vermont Medical Society, and which just came out with resolutions related to Medicare Advantage and the programs under traditional Medicare, and also Vermont Physicians for a National Health Program, which advocates for a nationally based single payer system. Today, I have, since I only have 15 minutes available, I want to confine my testimony to two issues. The first has to do with the problem of boarding. And this has been raised tomorrow. An op-ed piece that I wrote is going to be printed in VT Digger, and that'll be the third of three. The first of the three was written by a group of medical directors of Vermont's emergency departments at UVM, Central Vermont, and Northeast Regional, discussing the fact that patients are spending not just hours, but days waiting for a bed. And they suggest that there aren't enough beds. The second of the three op-ed pieces addressed that, agreed that there was a huge problem. And this was a nurse who said there's a shortage of nurses. And until we address that, we're not going to open up beds, because even if a physical bed is there, it needs to be staffed. The third of the three is mine. And basically mine discusses the role of Medicare Advantage plans and their behavior in contributing to this crisis. And as you all know, about over a third of Vermont Medicare beneficiaries are now signing themselves into these commercial Medicare Advantage plans. And unfortunately, there are four major disadvantages to Medicare Advantage plans, which I'll get to in a second. But one of them is obstructing medical care that providers feel is necessary. And this relates to boarding, in that the most aggressive and relentless area where Medicare Advantage plans delay and obstruct medical care is in allowing patients who have recovered largely from a medical illness to get transferred over for acute rehab. Frequently, these are people who are fairly weak to start with, and their situation at home may be somewhat marginal. And so they need to go to rehab to strengthen and make sure they can get to the bathroom safely and get around their house and get back to their usual level of function. And there's been a lot has been written about this, but basically Medicare Advantage plans, unlike traditional Medicare, are extremely aggressive about obstructing this. And I just want to say that the majority of people who need transfer over to post-hospitalization rehab are either insured through Medicaid or insured through traditional Medicare or Medicare Advantage, or they're in Medicare. And when the people who are in Medicaid or traditional Medicare, they go the very day that they're found to be stable enough to start their rehab process. And I can tell you that over the years, that the growing number of Vermonters who are in Medicare Advantage plans, observing this process, the average delay, which normally would be 0 days or at most 1, the average delay between the doctor saying this patient is stable and the patient's getting into rehab is at least 3 days and possibly 4. So this is one of many behaviors of Medicare Advantage plans that I hope that you guys can find a way to crack down on. I do want to address the issue of primary care availability and also nursing availability. The nurse who wrote the second op-ed piece is correct that we do have a shortage of nurses, especially on inpatient floors. And that I feel that the state should step up to this. And this is Vermont Physicians for National Program will be speaking more about this when they testify later this week. And I'm hoping to have time to be part of it. But the one most of what we're, or most or all of what we're asking for doesn't require money, but since I'm before the finance committee, I really feel that this committee should authorize an expenditure to create a vermonthealthjobs.gov website and help these hospitals. And there are two reasons why this is important. One is to get primary care and nursing positions filled. And the other is because for those of you who studied the Springfield Hospital Chapter 11 filing for bankruptcy, the list had three elements on it: increasing labor costs and the high cost of insuring their own employees. But the third was the extremely high expenditure to find traveler nurses, temporary doctors, and to fill in permanent positions. Because staffing firms basically have about, and they keep about 45% of the money when temporary physicians take a job. And it's pretty true for nurses. It's around 30 or 40% of the money goes to the staffing firm. This is a great amount of money. When I was hired at Springfield Hospital 7 years ago, they paid a staffing firm $35,000 just for me to sign on the bottom line. It's kind of a lot of money. And when this is happening with multiple positions, this is a huge expenditure. So I am requesting that the state seriously consider an expenditure to create Vermont healthjobs.gov or some website like that to find a way to recruit that won't just break the bank for, especially for the small hospitals, but really for all of them. There's been a lot of traveler expenses at UVM as well. So that's the first question I want to talk about. The other is a somewhat unrelated issue. I've been going on. Do you have any questions or shall I just proceed?
No, but I think some of your issues might be better in the Health and Welfare Committee. I know
Okay.
I was there for 5 years, second stint. I know we've done a lot with scholarships and training and, in the morning, 3 of us are working on our housing problems because we know we get teachers, nurses here and they can't find affordable housing. So we're working on some of those things, but
And we share jurisdiction on workforce development and work with health and welfare on anything that can promote job
so
access and
maybe you could
retention.
have
improvements.
Dr. Maliki into
Yeah.
economic development. That would be, you've got 3 of us up there. Economic development. Once we get our housing bill loaded this week, we'll probably be the top about workforce and creating websites and developing workforce. We just raise taxes in here.
Yeah, I'm aware of the problem. You're requesting that I discuss this with the health committee?
Well, I think the economic development. They
Okay.
do.
Right, so noted, and we will
They'll be in
take
touch.
that up, yeah. Yeah.
So-
and Medicare Advantage.
Yeah.
Anything else you'd like to say about that first issue?
No, I think we're really just looking at Medicare Advantage plans. And anything you can tell us about that. I know we have nursing homes have asked to come in. And we've had a hospital and we got tied up in the floor and had to cancel, but we're trying to get them back into.
Well, I'm requesting, okay, so the process of getting patients to rehab is
It's difficult.
clear. It's unobstructed if the patient is insured through Medicaid or traditional Medicare. I am requesting that those of you who oversee Medicare Advantage plans eliminate any medical necessity determination by Medicare Advantage plans. They're in Tampa or Dallas. They haven't seen the patient. The records from the doctor and the physical therapist and the rest of the staff are crystal clear. There's no scandal there. We're not putting patients, extra patients into rehab. Rehab places are generally nursing homes. They're not super pleasant. People just want to get stronger and get out of there. So
Okay,
this
but-
process of forcing them to stay in the hospital, I'm requesting that you eliminate the prior authorization process in general, but at the very least,
We
for
have
this-
been told that this is a federal program and we cannot regulate it.
ooh,
Okay, it's.
you can do
all
nothing about the prior authorization.
Medicare, Medicaid,
We could only regulate the licenses
We
of
can,
those. who
we can
propose.
regulate the licenses of insurance brokers, but. And we've had a discussion with them today about in order to offer lower rates with more service, you obviously are cutting somewhere and you just. But you'd think it would be cheaper for them to pay for somebody to go to rehab than keep them in the hospital.
No, it turns out that once the doctor declares the patient is no longer requiring acute care,
Yeah,
then the payment to the hospital ends. And until they say the patient needs inpatient rehab, the hospital is paid nothing. While the patient, and we can't discharge the patient from the hospital because we're saying they're not safe at home and they need rehab. So they sit in the hospital day after day, the hospital isn't being paid, and we're having to take care of them and do their physical therapy with no payment. So this is what's going on. This is really scandalous.
yeah, it is.
And that's why I was hoping that the Vermont state government would be in a position to do something about this. Other than complain to the federal CMS.
I would-
But this is really, it's really a gross scandal. I'll go on, I guess. The only other item I want to talk about today had to do with informed. When you buy a product, you're supposed to get accurate information about it. And there's now two parts to the privatization or commercialization of Medicare. One is the one everybody knows about, which is Medicare Advantage. And the other is, I guess stealth. I don't know how else to describe it, but traditional Medicare is also being subcontracted out to private companies. And I feel that in both Medicare Advantage and in this privatization initiative within traditional Medicare by organizations called some ACOs you've heard of, ACO Reach. There's a whole bunch of different programs approved by the CMS, and I feel that patients should be informed about them. And in regard to Medicare Advantage, the other part of the privatization, I've given you a list. One of the documents I have lists I put together a list of areas where consumers are not properly informed. And basically the four disadvantages of Medicare quote Advantage plans, I think consumers should be informed of all four. That there are narrow networks, and if you have a less common condition or and need a subspecialist, you're not going to go unless you're going to pay for the whole thing yourself. So they need to understand that there are narrow networks. The networks are particularly narrow for mental health provider availability. And there's been a lot of investigations about even when mental health providers are listed, you can't get an appointment. So that's the first one. The second one is that there really are copays, and they get quite big within Medicare Advantage if you actually get sick. They structure the benefit. Medicare Advantages are overpaid, and they structure they take the extra money and make the premiums really low and offer an eyeglass and dental benefit, but they don't make it cheap if you actually get sick.
Right.
There's very high copays. And
Yeah.
then, and the third and fourth problems are this medical necessity determination that they can deny care. They do deny care. They harass your primary care doctor with prior authorization requests, which is one of the many features that makes primary care difficult to practice. And then finally, there's a bunch of complex requirements that if you try to get out of a Medicare Advantage, which very sick people tend to do because of all the reasons I just said, there's a guaranteed issue, and this is included in S230, what to do about that.
We've heard that Blue Cross does have a guaranteed issue.
Right. I actually spoke with them about this, and they said, no, we charge $70 more. We don't refuse.
They charge 20% more, yes, because the risk is higher.
Yes.
You've been getting your teeth and your eyes done with an Advantage plan, and when you get heart disease, you want to come back to your doctor that's here. And it's the cost of the Medicare supplement plans that keep people from coming back, because you have underwriting, medical underwriting, and it's very expensive. But there's also adverse selection, and if we bring too many sick people back in, then everybody's supplement insurance will go up and we'll have more people that can't afford it. So we're trying to find this thin white line to walk down.
Yeah, my personal preference on that issue, I am also worried, as you just said, as you are, about adverse selection, that people would just join Medicare Advantage plans, and then the year they get sick, they'll just get out of it and go to a Medigap plan, if assuming that, that it'll cover them so much better, which Medigap plans do. So one possibility is to say there'll be a one-time ability for people to get out of Medicare Advantage, and that would have the additional benefit of raising discussion. But I don't think people would go into a Medicare Advantage plan if you grant a one-time option, say for this year. And I think it could generate a lot of discussion. But I'm very worried, as you are, as you just mentioned, that Medigap will undergo a death spiral if we freely allow everybody to get into a Medicare Advantage when they're well and then immediately quickly get out of it when they're sick. I'm really worried about that.
Have my next set of glasses paid for and have my teeth done, twice a year. But I don't have any major health expenses right now. So I could go there and I could be on it for 20, 30 years and then get sick and come back. And so you've got to find that pay-in so that you don't end up having all the really sick people come back. Because some of them would be absolutely playing the market. They'd figure out I can do this and then I can go back and this is what money would cost. So we're trying to do that. We're starting to lose senators. They have other commitments. So
so all I did was provide a list of ideas so that patients are properly informed about these programs.
And we will get that DFR. This bill calls for that brokers can't get paid for selling these programs. I don't think we're going to do that because the brokers are one way to make sure that the details are gone over. DFR is also working at having a website, and we're trying to figure out how to get it out with questions and people that can answer questions before you get into a Medicare Advantage, and where you can come and ask all those questions and all the things you should know before you sign up. So
there are two ways for patients to get some professional information about Medicare, their Medicare options. One is through insurance brokers. The other is through the Area Agency on Aging. And there are several on the state, and presumably that's much more objective. Insurance brokers get approximately $500 the first year when they enroll someone in Medicare Advantage, and half of that when they enroll someone in Medigap. So they're extremely biased. I mean, first of all, to sell the product, and second of all, to divert the patient to Medicare Advantage, regardless of whether that's in the patient's best interest. So I hope you can do something with that in this bill.
We know we can go after their license if they don't do the required disclosures.
How about the fees?
No, we were told we are preempted. That's part of the federal program, and we are preempted. We cannot say that brokers cannot receive payment selling this. And I'm pretty sure that the ratio was set up by the feds. Our only real hinge is in the license of the brokers or the companies. So if the broker isn't doing the required disclosures, then his license is at risk. We also need to get for little old people who watch the Hallmark Channel, Joe Namath and the little old lady with the glasses who's angry are on literally every 10 minutes for the entire open process. And they make you feel like you're stupid if you don't call up and sign up today. We can't stop that, but we can have a way, we've got to have some counter detailing. Remember when we did that with drugs? We need to have a way to publicly let seniors know you know, if it sounds too good to be true, it isn't. So that will work.
I wrote an op-ed piece. I can email it to Keisha on that very topic, how
That would
to
be great.
explain this to the general public.
Okay, thank you.
You're welcome.
Okay.
Thank you for having me.
Thank you, anytime. And
Take care.
we're seeing you in economic development. Okay.
Sounds good.
Good.
Thank you.